Members, we now move to the further consideration stage of Abortion Services Safe Access Zones Bill. And I call Ms Claire Bailey to formally move the bill.
Moved.
Thank you. Members will have a copy of the marshalled list of amendments detailing the order for consideration. The amendments have been grouped for debate in the provisional grouping of amendments selected list. There is a single group of 5 amendments which deal with publication of zones and offences, and we will debate the amendments in turn. I would remind members intending to speak that during the debate on the single group of amendments, they should address all of the amendments on which they wish to comment. Once the debate is completed, any further amendments in the group will be moved formally as we go through the bill, and the question on each will be put without further debate. If that's clear, we will now proceed. We come to the single group of amendments for debate. With Amendment 1, it will be convenient to debate Amendments 2 to 5. I call Ms Claire Bailey to move Amendment 1 and to address the other amendments in the group, please.
Moved.
Yes. Do you wish to continue, please?
Thank you, Deputy Speaker. And I'm very pleased to be reaching this stage of the development of this bill. And for the record, I would like to put my gratitude on record again to the Committee for Health and the Office of Legislative Counsel, the Department of Health and all the other stakeholders who have helped to get us this far. The amendments that we've worked on and passed the consideration stage have gone some way to get this bill to this point where it will be effective and workable once passed. But a number of issues did come up at consideration stage that required further work to fully achieve this. So Amendments 1 and 2 before us today amend clauses 1 and 2 respectively, so that it is clearer that the Safe Access Zone will only apply to a premise while it meets the definition of a protected premise. The original provision set out that a Safe Access Zone would only apply to a protected premise. It was not explicit that there was a mechanism for a zone no longer applying. So Amendments 1 and 2 now outline how that can occur. Amendment 3 is a tidying up of Clause 4 following amendments made to that during consideration stage. The amendments set out how a zone would be established and the role of the department in that process, but there was an omission in relation to premises where information, advice or counselling about abortion services were provided. So this is a minor change to correct that and ensure that they're included within this section of the bill. Amendment 4, I know that the member for North Antrim has submitted this amendment to add a reasonable excuse defence to the offence outlined at Clause 5.2, and I understand the concerns that were raised that the effect of Amendment 5 at consideration stage of the bill meant that this could be a strict liability offence. And while I stand over that amendment to remove the defence, as the PS and I were clear about the impact that could have on the enforceability of the legislation, it is not, nor has it ever been, my intention to unnecessarily criminalise anyone by this bill. The offence outlined in this bill is narrow in scope, despite what some have tried to allege. This bill does not ban protest. It does not ban silent prayer. It simply regulates behaviours that are targeting women, attempting to stop them accessing lawfully available healthcare and information. That's all. And allow staff to go about their jobs unimpinged and impeded. So as such, I do not envisage many examples where someone might have a reasonable excuse for engaging in behaviour with the intent of, or reckless as to whether they have the effect of influencing, preventing or impeding access, or causing harassment, alarm or distress to a protected person attending a protected premise. But nevertheless, I do not see any issue with including it to give additional reassurance around the operation of this clause. So I will be supporting Mr Allister's amendment to ensure that this is not a strict liability offence. And I want to thank him for his assistance and willingness to work with me to get an agreement on how to bring this forward. And I have no doubt at all he will speak to this in great detail. So Amendment 5 is really the issue around how the safe access zones, once established, are published and the public are made aware of their existence. And this has been subject to extensive discussion throughout the passage of this legislation. And at consideration stage, I brought forward some changes to this process with the assurance that the detail of how it would be done is best dealt with through a policy paper from the Department of Health. And I know that Ms Bradshaw also sought to do that with amendments that she subsequently didn't move. Now, while that policy paper still remains the case, Amendment 5 in front of us today seeks to elaborate on this more clearly in primary legislation for the avoidance of any doubt. The amendment expands the requirement to publish a list of protected premises and the extent of their safe access zones so that it is clear there is a need to ensure that the existence of zones is adequately publicised more generally so that people can be sure of where they stand, literally, in relation to the law. So the amendments are fairly technical in nature in order to provide a degree of clarity and certainty, and I hope that members can support them today, and I will be supporting all 5. Thank you, Deputy Speaker.
Thank you. Agus na siadam sir Caithfirleach an coiste sláinte Colm Gildernú hon cainse. Call the Chair of the Health Committee, Colm Gildernú.
As Chair of the Health Committee, I would like to advise the Assembly that the Committee has not had an opportunity to consider the amendments before us here today in the bill sponsor's name and in the name of Jim Allister. Therefore, the Committee for Health has no position on these amendments. And just as Sinn Féin spokesperson last Jan Corley, I wish to indicate that we will be supporting the amendments in the name of Claire Bailey and opposing those in the name of the amendment in the name of Jim Allister.
I call Pam Cameron.
Mr Deputy Speaker, I don't intend to speak for too long on the amendments before the House today at further consideration stage of this bill. The position of my party is clear and our concerns about the legal implications of this bill remain unaddressed. From the outset of today's stage debate, I want to again reiterate that patients, staff and visitors to health service premises should never be subject to acts of abuse or intimidation, nor should anyone else in society for that matter. And I believe this bill will not have the impact its supporters believe it will have, and it will almost certainly result in protracted legal action. In terms of amendments 1, 2 and 3, all are technical amendments attempting to clarify aspects relating to the premises and their notification to become a registered protected premises, and the premises retain all power to self-notify or reverse notification. The process for doing this, Mr Deputy Speaker, remains vague. These amendments do nothing to alleviate the concerns around the lack of accountability in this process. There are no additional powers or oversight for the Department, and the Department still has no authority to reject a notification. In terms of Amendment 4, my party are supportive of Amendment 4 to Clause 5 proposed by Mr Allister. This amendment would give some reasonable protection to those who act reasonably within a safe access zone from prosecution under the offence of influence. As we have stated before, influence is a broad and undefined term in the bill, and the bill does not distinguish harassing, abusive or criminal behaviour from influencing behaviour. I would urge members from the Assembly to think carefully about the implications of supporting such vague legislation, Mr Deputy Speaker. To criminalise those you deem to have a different opinion is a very dangerous path to go down. In addition to this, Mr Deputy Speaker, there also has been very little consideration of the impact of policing resources, which, going by the so-called draft budget, will be facing severe frontline cuts. Amendment 5 extends the scope of the requirements for the Department to maintain a register of protected premises. As a result of this amendment, the Department would have to publish a list of premises to bring buffer zones to the attention of members of the public likely to be affected. And the Department would also have to ensure that the premises themselves bring the zones to the attention of the wider public. Again, there is great ambiguity around what this actually means. Would it mean that the Department would have to force health premises to display signage against their will? Would it end up with trusts having to write to every pregnant woman with an appointment? We hold serious concerns around awareness raising of these sites. And surely my fear would be that this would increase the potential for protests, which the bill sponsor is aiming to prevent within these zones. In conclusion, Mr Deputy Speaker, it remains my position that a thorough review of existing harassment laws would have been a more suitable and fair way forward, and others obviously have decided not so and decided to push ahead with this bill, despite its many grey areas and ambiguity. The DUP will be opposing all of the amendments moved by the bill sponsor today and supporting Mr Allister's amendment. Thank you.
Sir Colin McGrath on Canchai call Colin McGrath.
Thank you very much, Mr Deputy Speaker, and I welcome the opportunity to speak on this at its further consideration stage. I'll not be speaking for too long, Mr Deputy Speaker, but will say that the SDLP will be supporting the bill sponsor with Amendments 1, 2, 3 and 5. The amendments that are put forward by the sponsor are a further tidying up of the legislation, and that is to be welcomed. They are mostly technical in nature, with the exception of Amendment 5, which provides further clarity on the need to publish a list of protected premises. I'm a little bit concerned that the amendment being put forward by Mr Allister offers those who would be subject to this legislation, I think, a get-out clause, including the defence of without a reasonable excuse. Yes, of course, sure.
Member for taking an intervention. Would the member agree with me that this is not in line with previous pieces of legislation that are also about protecting women? For example, the domestic abuse bill. The reasonableness argument is not an argument of defence.
I thank the member for the intervention, and I'm not 100% across the other bill that she mentioned, but I certainly take the point that if we leave too vague a definition in legislation, it creates confusion, it creates problems, and I was actually just going on to say that I'm concerned that those individuals who will be subject to the ramification of this will, if offered a get-out clause, do their very best to try and bend those rules and try and push reasonable excuse to its absolute furthest to try and enable them to find some sort of space within the legislation to continue with their behaviour. So I'm afraid that it's just too ambiguous and therefore we would have difficulty supporting it. And also, just to reiterate once again, Mr Deputy Speaker, that contrary to some of the emails that we have been receiving over the last weeks, this is not about censorship. And in fact, this legislation that we're being presented with is not about abortion. The legislation is about the capacity for an individual to enter a building without feeling and having fear of harassment, of intimidation, or someone trying to make them feel ashamed. And therefore, the SDLP will be... yes, of course.
The member speaks in terms in respect of Amendment 4 about being fearful of giving some opportunity to people to bend and formulate an excuse. Legislation puts that exclusively in the hands of the court. It's for the court to decide whether something is a reasonable excuse. It's not self-certification, as appears in other parts of this bill, by the accused. It's for the court to decide. So there is the protection of the court having to be persuaded it's a reasonable excuse, not just something you claim and that's the end of it.
I thank the member for the opportunity to be able to respond to that thought that he has by saying that that is after the legislation has been passed. We can provide the clarity in this legislation, but to actually provide confusion that then requires people to go to the courts afterwards seems a clunky way to go about developing legislation. We put the clarity in the legislation and then there is no need to go to the courts afterwards. But if you put in ambiguity into legislation, it simply creates problems. And what we're trying to do here is to remove those problems by providing the clarity as best we can. And to that end, as I say, we will be supporting Amendments 1, 2, 3 and 5 and opposing Amendment 4. Thank you.
I call Paula Bradshaw.
Thank you, Deputy Speaker. I rise to support Amendments 1 to 3 and Amendment 5 and to oppose Amendment 4. I will focus my remarks mainly on the most detailed amendment, that being Amendment 5. Amendments 1 and 2 are a sensible technical addition for clarification, and Amendment 3 is a minor change to more thorough linkage within the bill. So Amendment 4, we believe, is too wide in scope, leaving far too much to be determined by the word reasonable. This is the third time I've stated that safe access zones exist elsewhere to, and I quote from the Queensland Law Commission, to protect the safety and well-being and respect the privacy and dignity of people accessing health services. This is not about censoring public protest, but an issue, as some misleadingly claim. It is about stopping specific and targeted harassment of people accessing services to which they are entitled. So in supporting Amendment 5, I've mentioned in both plenary debates thus far my concern about the clarity about what constitutes a safe access zone, and in committee I've raised several times. Additionally, evidence was brought to committee by the bill sponsor emphasising that there would be a potential defence under the legislation as to what stands that those engaging in abuse did not know that they had been approached by a protected person, which for me included that they did not know they were in a zone. And I appreciated the clarity in the Minister's letter and the bill sponsor's evidence to committee around this. It bears re-emphasising that one successful prosecution for harassment outside a clinic was overturned precisely because the judge could not be clear that the unpleasant behaviour constituted criminal harassment. This is exactly why this legislation is necessary, but also why it is essential to be as clear as possible about precisely what it entails. That's why I'm pushing for an amendment. I was pushing for an amendment, much like Amendment 5. The reason for this is not just to do with legal defence in the event that an offence has been committed, though we can see from past experience that is an issue, but it is to do with prevention, with knowing when the police should be called, and indeed about providing clarity to prevent offences from occurring in the first place. My own view was initially that signage may be necessary to accomplish this, but I am happy with subsection C of the new clause 7. This allows the operators, and ultimately therefore also the department, to bring the public's attention to the existence of the safe access zone as appropriate, and this may or may not involve signage. So in conclusion, Mr Deputy Speaker, I hope that the bill, as clearly strengthened particularly by this Amendment 5, can now proceed swiftly to final stage. I congratulate all those involved with getting this far, and I think, again, as Assembly, we are now making positive steps forward. Thank you.
Did I notice earlier Mr Chambers indicating? Okay, thank you. Will I call you now? Call Alan Chambers.
Thank you, Mr Deputy Speaker. Mr Deputy Speaker, certainly over the last number of days, I personally have been receiving a lot of emails, as indeed have my colleagues in the Ulster Unionist Party, from pro-life groups and pro-life individuals. My mailbox would probably represent the same level of a huge level of emails that I received when debates in here were actually focused on abortion. So it's disappointing that that's the way that this debate and this legislation has been viewed by some people. The abortion is a matter of conscience for our MLAs in the Ulster Unionist Party. That has not changed. That remains the same. And so our position is not influenced by either pro-life or pro-choice arguments. This bill and the amendments that we have in front of us today really are designed to create a safe environment for vulnerable women who want to visit these clinics to seek advice. They're also in place to protect members of the public who may be entering those same buildings on completely unrelated business, who may even be accompanied by children. It's also designed to give some form of protection to staff who work in those clinics. But the main issue here, and I think that people out there don't seem to be listening, they don't seem to be hearing what the thrust of this legislation is about. It's not about abortion, it's about a women's health issue. And women are perfectly entitled and should have the right to seek advice on this topic and get that advice which is available in these clinics. And I know that some of the, well, most of the letters, a lot of them are copy and paste, seem to paint a completely different picture about what actually takes place outside these clinics by protesters. And the evidence that we listened to in the Health Committee, both from trust officials and from the police, were very harrowing. And I think unacceptable in a civilised society that people should behave like that. But against that, people should always have the right to protest. And I don't think it's a particularly big ask to ask people to take their protest 150 metres away from the front door of these clinics. So certainly today I'd be supporting Amendment 1, 2, 3 and 5. And certainly looking forward to hearing Mr Allister make the case for Amendment 4, but at this stage I've been minded not to support it, but we will listen to the arguments. Thank you, Mr Deputy Speaker.
I call Liz Kinnins.
And I too rise to speak in support of Amendments 1, 2, 3 and 5 and against Amendment number 4, mainly because I don't think that you can have reasonable excuse for harassment of women, whether it's intentional or not. And we talked about that at length at the last stage of the debate. I do fear, like other speakers have alluded to here, that this could potentially open the floodgates and in a sense put the bill on its head, because we could have so many cases before the courts that it would never have any real impact. I'm going to go back to looking at how intention is so important, because I would say a lot of the people involved in protests don't necessarily intend to cause the harm that is caused by these protests, by the, whether they're standing with a sign or whether they're chanting or raising comments to women coming and going. But I think the point of the matter is, and why we're at this stage, is it has had such a huge impact on so many people, as the previous member mentioned, not just women who are trying to access healthcare, but also staff, members of the public and other patients accessing a range of services within the hospital sites and other healthcare sites. So I think that we have to have it nailed down to an extent so that there's no ambiguity in this piece of legislation, that it's clear and that the needs and the rights of women are protected at every stage. So I look forward to hopefully seeing. Yeah, I will.
The member agree with me, as I've already said, that all of the other pieces of legislation that we brought through this House around protecting women, particularly the Domestic Abuse Bill, the Stalking Bill and other pieces of legislation to protect women, and these are some of the most vulnerable women in our society in some of the most vulnerable and harrowing circumstances of their entire life, and we need to protect them, and reasonableness must be removed as an excuse.
Yeah, and I agree with the member. As others have said, and we talked about it at the last stage of the debate as well, this isn't about censorship. It's actually, people can still protest on this issue, just not in the vicinity of where the safe access zones will be established. So that's not being taken away from them, but if we were to allow for a reasonable excuse, it may infringe on the rights of the women who are trying to access the healthcare that they so vitally need at such an important time in their lives. I hope that we can pass this today and get it passed through the final stage.
I call Sinead McLaughlin.
Thank you, Mr Deputy Speaker. As my colleague Colin McGrath has indicated, the SDLP will be supporting Amendment 1, 2, 3 and 5, but we will not be supporting Amendment 4. I'm really pleased that this bill has been refined in the manner in which it has been, because I believe it strengthens it on its journey on this legislative process, and it's a really good example how collectively we work in order to deliver for our constituents. And I want again to thank the bill sponsor, Ms Bailey, for bringing this important piece of legislation forward. And as I said, as we spoke the last time we spoke on the bill, this is about affording people the right to access healthcare free from harassment and abuse. It won't prohibit prayer, it won't ban protest. You will still be able to do all those things. So what won't you be able to do? You won't be able to harass or intimidate patients and staff outside a clinic that has a designated safe access zone. Healthcare centres are not appropriate sites for that kind of language, imagery and behaviour that these protesters display regularly and on a weekly basis. I recently had the privilege to listen to Cara from Supporting Women Uri speak at a Derry International Women's Day rally. In the face of intense harassment at Daisy Hill Hospital, they offer support and chaperone services to women. They have taken things into their own hands to protect their community, but they shouldn't have to do this. And that is why this bill is needed, and that is why those amendments must stay. So what else will you no longer be able to do? You won't be able to interfere with women's healthcare choices as they enter a clinic. This is what many of these so-called protesters openly admit to attempting to do. Indeed, I have received a letter from one who plainly stated that they see it as their opportunity to force last-minute changes of heart. Yes, everyone has the right to free speech, but no one has the right to obstruct or intervene in a personal healthcare decision. Absolutely no one. Let's us please trust women with their healthcare choices. Let us afford them the right to access healthcare free of harassment and abuse. This is really not a big ask. Mr Deputy Speaker, I support the further consideration stage of this bill, as I've indicated.
I call Jim Allister.
Thank you, Deputy Speaker. Amendment 4 is very focused. It's focused on the criminal offence which arises within this bill in Clause 5, and it's focused upon introducing a very modest modicum of acceptability and reform to that offence. Because as that offence stands, and of course it is a very wide offence, it ranges from embracing harassment, abuse, to the mere issue of influence, but as that offence stands, it is an absolute offence. That is to say, like driving your car with no insurance, there is no answer to it. You cannot ever defend yourself against it. It is an absolute offence. And that in the criminal calendar is very, very rare. And it's very rare for a very good reason. Namely, that the basic premise of a criminal offence is that it comprises both the actus reus, that of doing the act, and the mens rea, that which is informed by the mind. And within that ambit, it is overwhelmingly the case that our law provides reasonable excuse for someone accused. So by putting that into this Act, into this bill, we are being entirely compatible with the trend in creating criminal offences. To say, not to this Assembly, to define what a reasonable excuse is, but because every case is different, to say to the court, you decide if the defence is raised by someone accused, whether or not what they did or said was reasonable. It's not this House deciding what's reasonable. Judging by this House, there could be nothing that is reasonable. Well, when I develop this point, I will. So we're in a situation where we are saying, in respect of this very, very sweeping offence, which includes silent actions designed to influence, that someone accused of that should be afforded the basic tenet that applies in respect of virtually every other criminal offence, that of having a reasonable excuse, upon which the court would then be required to rule whether that which was done was reasonable or not. The alternative is the totalitarianism offered by Sinn Féin, the SDLP and the Alliance, that under our rule of law, you shall simply, as you would in Russia, decree it's an absolute offence. You cannot protest. It can never be reasonable to do so. There is no comprehension of there being a reasonable excuse for doing that. So, because it so offends the very principle that this House is so intent on defending, namely that of death through abortion, that you can never have a reasonable excuse to dare to breathe opposition to it. That is the ultimate in totalitarianism. And that is what the Alliance Party, Sinn Féin and the SDLP are embracing today. All they are asked to support is the introduction into this legislation of the very lowest common denominator of criminal defences in respect of a criminal offence, namely, let the court decide what was done was reasonable or not. And it's not by your standards or mine, it's by the standards that the court would set in that respect. Why does that offend anyone who believes in innocent till proven guilty? Why does that offend anyone who believes that when criminal prosecutions are brought, someone should have the right of a defence? That only offends if you're an apostle of totalitarianism, because that is what absolute offences are about. And I welcome the fact that the sponsor, and there's no one more enthusiastic about this bill than the sponsor. I accept the fact that both in the consideration stage and since, she has accepted the basic tenet and principle that we should create criminal offences which do not expunge that most fundamental tenet of letting a court decide whether or not something is reasonable conduct. To do that and to create an absolute offence is really a stretch way beyond where I would say this Assembly should wish to go. I'll give way.
Thank the member for taking the intervention. Would the member agree with me, as we were advised as a committee whenever I was on the Justice Committee, that not having the reasonableness excuse in there does not prevent a judge from actually looking at a case as every individual case and seeing what the particular circumstances of that case were?
With respect, the member is absolutely wrong. Clause 5 utterly excludes a court from looking to see, is there something reasonable here which caused this? Because Clause 5 is written in absolutist terms. If the person does any of these things, then because there is no defence of reasonable excuse, they are guilty as charged automatically. It's absolute. Once you prove the actus reus of this offence, then endgame, the offence is proven. And that's why the member in previous interventions has been articulating or attempting to articulate a case against reasonable defence, because she wants to be totalitarian. She wants to be absolutist. She wants to rob any accused person. And sometimes in other circumstances, she's quite defensive of accused persons and their rights. But she wants to rob any accused person under Clause 5 of that most fundamental right to say, but what I did was reasonable. And for the court then to decide, was it reasonable? Once you exclude that, then you rob the court and the accused of the fundamental right to decide whether what was done was or wasn't reasonable. That is totalitarianism writ large. That is suppression of protest writ large. That is the fundamental denial of a most basic tenet of in respect of any offence that arises in the criminal calendar. So it's not, as someone said, a get-out clause, because it's not that simply the accused can say, I had a reasonable excuse. No. They can say, I think I had a reasonable excuse, but you, the court, decide whether or not it was a reasonable excuse. That's what this modest amendment is all about. The one hesitation I had in bringing this amendment was lest I made this bill human rights compliant, because at the moment its absolutism, I think, really does stretch its human rights compliance. But I do think that this offence, it's the will of the House that such offence exists, that at least should have that basic component, that virtually every other offence in the criminal calendar has, and that we should not be so dogmatic and totalitarian in our approach to refuse to even contemplate a court maybe being able to find that what was done was reasonable. I give the example in the consideration stage of the mother, the 14-year-old girl, who accompanies her against the child's will down to the abortion clinic, pleading with her not to have an abortion, giving her motherly advice. And I said, Clause 5 makes that mother the criminal. Clause 5, if it were amended in this way, would give that mother a fighting chance of not being a criminal, because she could say it was a reasonable thing to do as a mother. But members in this House, seemingly the majority in this House, want to criminalise that mother, want to put it beyond doubt that she could never have a reasonable excuse. And that seems to me to be an ultimate exercise in that oppressive totalitarianism that some are so anxious to embrace. And indeed, maybe embrace it, because who's proposing the amendment, never mind the logic or the sense of the amendment, because I find in this House a great dearth of understanding of what the criminal law means and what it should mean, and a great assault upon its integrity. And this is one of the clauses that attacks it most head-on. So I do say to this House, pause, think, do as the sponsor is going to do, and support this very basic tenet of introducing into this bill a reasonable excuse which the court will decide. Not us, not the accused, the court. And shouldn't that be what our courts are all about? Thank you.
I call Claire Bailey to wind.
Thank you, Deputy Speaker, and thank the members for their contributions. It's an interesting debate on this particular Clause 4, but despite that, I just want to thank the members who have supported this bill so far, and Ms McLaughlin in particular, who, when she speaks, obviously gets exactly what's happening. And other members in Sinn Féin, and I know Ms Bradshaw as well, and their continued work with women on this, because this legislation is urgently needed. And I hope that those who don't realise that yet can begin to understand that and start to support its passage. It's vitally important that this legislation finds the correct balance of competing rights, and that's always been my intention from the start. And of course, that balance has to be proportionate and has to be justified, and I do believe that these final changes and amendments will help to achieve that. When healthcare staff are telling us that they've had to relocate services due to interference and influence by those seeking to disrupt services and people's access to them, when these new locations have had to be kept secret to prevent further interference and targeting of any services, when they tell us that women have been dissuaded from accessing services while they are physically miscarrying pregnancies, putting themselves at serious and immediate risk due to the influence of those seeking to interfere with people accessing services. When the Health and Social Care Trust have to install safety glass in their windows due to the level of threat and their duty of care to their staff and service users because of the ongoing behaviours at their doors. Then vulnerable women, I have watched vulnerable women run into oncoming traffic to avoid the deliberate targeting of them accessing services. We need to pay attention and do what we can to ensure safe access to abortion services, whether or not we hold deeply held beliefs. Deeply held beliefs are not licensed to influence others unabated and unchecked. And this bill seeks to be a proactive bill to prevent harm happening, not a reactive bill that's set up to deal with harm once it's happened. We know that the harm is happening. let's try and stop the harm being caused. Now, I do fully accept the reasonable excuse debate here in terms of getting a balance of competing rights. And I have looked through other legislation, and it does occur. And under Section 67 of the Anti-Social Behaviour and Crime and Policing Act 2014, it's explicit, and it states that it is an offence for a person without reasonable excuse. And then goes on to explain that to do anything the person is prohibited from doing in public space protection orders or fails to comply without reasonable excuse. Under Article 9, and it's not the only article, but I will use that as the example. Article 9 is the protection to freedom of thought, belief and religion. But it comes with conditions. And those conditions are that public authorities cannot interfere with your right to hold or change your beliefs. But there are some situations in which public authorities can interfere with your right to manifest or show your thoughts, belief and religion. And this is only allowed where an authority can show that its action is lawful, necessary and proportionate. And it's that word proportionate, in order to protect public safety, public order, health or morals, and this is the important, the right and freedoms of other people. So there is no absolute right to force your held beliefs on anyone, because they have the right and the freedom to not have that forced upon them. Give away.
I'm just interested maybe to develop the point is that if you include the reasonable excuse message and then a court further decided at a point that there was a reasonable excuse for the behaviour and the behaviour continued, would that not make you unhappy and therefore more or less nullify the fact of actually having the legislation, because then the behaviour would continue?
I thank the member for that, and thank you for allowing me to reiterate this point. Under articles that do have the caveats, what would be a reasonable excuse under this legislation that is explicit? The offences outlined in this bill, again, are narrow in scope, and despite all the debate, and I'm going to go back and pay close attention, so this bill does not ban protest. It does not ban silent prayer. I have given a list of examples of what I have experienced in terms of the impact and outworkings and what health trusts have said is happening at their doors. I've yet to ever meet the example that Mr Allister keeps giving to this debate, where a mother is hanging on to a 14-year-old child trying to go into the door. I haven't met that one yet, but might happen. Certainly.
The bill is designed to prevent the harassment, to prevent that protest from crossing the line into harassment. What possible reasonable excuse could there be for harassing women in that circumstance?
Thank the member for that. That's exactly it. Okay.
Clause 5, I'm surprised the chairman hasn't read it, because it begins to indicate that the offence is sufficient to be committed if it's the mere influence. It doesn't need to come near harassment or abuse. Influence is enough.
I think the intervention was for me, Mr Allister. Thanks for your answer. But I'll go back, and this is where I can accept it, because I cannot envisage any example where someone might have a reasonable excuse for engaging with the behaviours as explicitly set out in this bill with the intent of, or reckless as to whether, they are influencing, preventing, impeding access or causing harassment, alarm or distress to a protected person accessing protected premises. And of course, under the enforcement in clause 6(1)(a) of the bill, the first option for a constable when dealing with any incidences allows them simply to direct a person to leave the safe access zone. So this bill is not designed to be very heavy-handed. This bill is designed to create a safe space where the protest, if that's what it is, or people with other views that they hold, can continue to influence, lobby and behave, should they continue to choose to do so, elsewhere, but away from the doors, and not impeding access, and not causing harassment and alarm, and not making staff fearful, and not causing health trusts to put on security staff, to have safety glass in their windows, to move services, so as women don't run into oncoming traffic, so as they're not splashed with holy water, so as they're not told that they're murderers entering healthcare facilities, so they're not told that they have blood on their hands, that they can, unimpeded, access services without harassment. Now, if someone believes that they have a reasonable excuse to do that in an access zone, that would be a fair stretch of the imagination to allow a judge to agree with that. And for that reason, I will allow a reasonable excuse, as is provided for in other criminal legislation. And in the case in Matlock Lane, where a case was taken for this behaviour at a Mary Stopes clinic, and that was in Ealing Borough Council, and I have that here as well. And again, that Ealing Borough Council used their powers under the Antisocial Behaviour, Crime and Policing Act 2014 to establish public space protection order around the Mary Stopes clinic. And that act makes it an offence for an individual not to comply with the requirements of a PSPO without reasonable excuse. So what reasonable excuse if under Article 9 there are caveats where the state can intervene in order to ensure the balance of those rights, but to ensure that people are not unduly interfered with according to someone else's belief system. And it's for that reason that I will support the reasonable excuse. I will, yep.
Having said that, would you encourage the other parties in the chamber who have already nailed their colours to the mast in opposition to the amendment number 4, would you be encouraging them to reflect on their position?
Thank the member for that. I'm going to just say that those parties who have, and I have no doubt have paid a great deal of attention to this, that action is proportionate when it is appropriate and no more than necessary to address the problem concerned. I feel that the provisions in this bill are proportionate and no more necessary to address the problem that we all acknowledge is happening to women, to healthcare staff, and I can see no other healthcare service or facility where this would continue to be tolerated, where the level of, I don't know whether deliberate or not, but ignorance of harassment legislation and how it fails to apply or be sufficient in these circumstances can work. This is a preventative measure where harm can stop rather than harm being done and then addressed. Now, if anyone feels that they have a reasonable excuse to continue with that behaviour, I, for one, would like to hear it. Thank you, Deputy Speaker.
Amendment proposed to Clause 1, page 1, line 8, insert words as printed on the marshal list. The question is that Amendment 1 be made. All those in favour say aye. Aye. Contrary, no. All those in favour say aye. Aye. Contrary, no. Clear the lobbies. The question will be put in 3 minutes. Order, members. Would members resume their seats? Order, members. I would again remind members that if you have proxy voting arrangements in place, you do not come into the chamber, and we need to obtain or maintain social distancing. Before I put the question, I would again remind you that it would be preferable if we could avoid a division. The question is that Amendment 1 be made. All those in favour say aye. Aye. Contrary, no. No. All those in favour say aye. Contrary, no. Do we have tellers? Order, members. The following tellers have been appointed. Tellers for the ayes, Sinead McLaughlin and Paula Bradshaw. Tellers for the noes, William Irwin and Mervyn Story. Before the Assembly advise, remind you that as per Standing Order 112, the Assembly currently has proxy voting arrangements in place. Members who have authorised another member to vote on their behalf are not entitled to vote in person and should not enter the lobbies. And again, remind members to maintain social distancing and a 2-metre gap where possible. Clear the lobbies. The Assembly will divide. Ayes to my right, noes to my left. Secure the doors. Order, members. Would members resume their seat? Clerk, please read the result.
85 members voted. 57 members voted aye. 28 members voted no. The amendment is made.
The amendment is made. The amendment is made. Unfasten the doors. Amendment 2 has already been debated, and I call Claire Bailey to move formally Amendment 2.
Moved.
Amendment proposed to Clause 2, page 2, line 2, insert words as printed on the Marshall list. The question is Amendment 2 be made. All those in favour say aye. Contrary, no. I think the ayes have it. All those in favour say aye. Contrary, no. I'm hearing no's from the DUP benches and Mr. I think the ayes have it. I think the ayes have it. I think the ayes have it. The ayes have it. The ayes have it. Amendment 3 has already been debated, and I call Claire Bailey to move formally Amendment 3.
Moved.
Amendment proposed to Clause 4, page 2, line 27, insert words as printed on the Marshall list. The question is that Amendment 3 be made. All those in favour say aye. Contrary, no. Contrary, no. I think the ayes have it. I'm hearing no's from the DUP benches and Mr. Allister. I think the ayes have it. I think the ayes have it. The ayes have it. The ayes have it. Amendment 4 has already been debated, and I call Jim Allister to move formally Amendment 4.
Moved.
Amendment proposed to Clause 5, page 2, line 39, insert words as printed on the Marshall list. The question is that Amendment 4 be made. All those in favour say aye. Contrary, no. All those in favour say aye. Contrary, no. I have been advised by party whips that in accordance with Standing Order 113 5B, that there is agreement that we can dispense with the 3 minutes and move straight to a division. So now I call for tellers. Do we have tellers? Order, members. The following tellers have been appointed. Tellers for the ayes, Jim Allister and William Irwin. Tellers for the noes, Linda Dillon and Sinead Ennis. Again, remind members for the requirement to maintain social distancing whilst the division takes place. Please maintain a 2-metre gap between yourself and others, and when moving around the chamber, and especially in the lobbies. Clear the lobbies. The Assembly will divide. Ayes to my right, noes to my left. Secure the doors. Order, members. Would members resume their seat? Clerk, please read the result.
84 members voted. 40 members voted aye. 44 members voted no. The amendment falls.
The amendment falls. The amendment falls. unfasten the doors. Amendment 5 has already been debated, and I call Claire Bailey to move formally Amendment 5.
Moved.
Amendment proposed to Clause 7, page 3, line 31, leave out and insert words as printed in the Marshall list. The question is that Amendment 5 be made. All those in favour say aye. Contrary, no. All those in favour say aye. Contrary, no. I think the ayes have it. I'm hearing no's from the DUP benches, and I think Mr. Allister, but I think the ayes have it. I think the ayes have it. The ayes have it. The ayes have it. And that concludes the further consideration stage of the Abortion Services Safe Access Zones Bill. The bill stands referred to the Speaker. I'd ask members to take their ease for a few moments. Order, members. The next item in the order paper is a motion on accelerated passage for the Preservation of Documents Historical Institutions Bill. Please read the motion.
That the Preservation of Documents Historical Institutions Bill proceed under the accelerated passage procedure.
And I call Alan Chambers to move the motion.
Thank you to everyone who joined us for our Abolish Abortion NI coverage of this afternoon's proceedings from Stormont. Some absolutely shocking developments, and truly we have moved into the situation of moving Stormont to something similar to what you would see in the Duma in Moscow, the laws that are now being passed by our MLAs. We will have an update at 8 p.m. tonight on Facebook and on YouTube. Do link in again. We'll have a full analysis of the votes, the amendments, and what they mean for free speech, what they mean for religious freedom, and what they mean for the right to speak against abortion. So thank you very much for being with us this afternoon. Take care.